Legally Speaking. We are so glad that you have joined us. We have an exciting event scheduled for today. We have an amazing guest for today. First, I'd like to just tell you what Legally Speaking is all about. It's an opportunity for women lawyers to come forth and share legal information. Our goal is to help alleviate confusion as it pertains to legal issues. However, we are not providing legal advice. If you need legal representation for a legal matter, we recommend that you contact an attorney to have them review your legal case. However, in general, we'd like to share information so that we can educate and give you comfort as you pursue your legal matters. Our guest today is Judge Bridget Clayton. Let's give Bridget a hand. I am so excited about having Attorney Clayton. She is phenomenal. She's been in the Jackson area. And before I go any further, I'd like to just give a shout out to Women for Progress. You may know already, but Women for Progress launched this podcast because our president, Willie Jones, thought it would be a great idea to share legal information. We've been doing it for several months, and we've had people send questions to us on issues that they're interested in. Last week, I received several questions regarding the issue that we have today. So it would be befitting to proceed with the biographical sketch of Judge Bridget Clayton. Bridget Clayton was admitted to practice law before the United States Court of Appeals for the Fifth Circuit in New Orleans, Louisiana. The U.S. District Court for the Southern and Northern Districts of Mississippi, the Mississippi Supreme Court, and all state courts in Mississippi. She served as a municipal court judge during the administration of 5 mayors for 10 years within the city of Jackson. She is a Meridian, Mississippi native and attended Meridian High School, where she graduated with honors. She attended Meridian Community College, where she earned her AA degree in 1980 with honors. The University of Mississippi, earning her Bachelor's of Arts degree in Political Science in 1982, and the Mississippi College School of Law, earning her Doctorate of Jurisprudence in 1994. She established the law office of Bridget McDade Clayton in 1998, and she represents clients from the plaintiff's and defense perspective in civil litigation, also in the following areas of law: employment law, family, estate and trust, personal injury, and corporate defense. She's also served as an assistant Hinds County prosecutor, as well as served as a defense counsel of clients in criminal matters. Judge Clayton has worked for the Mississippi Secretary of State's office as Bureau Director of the Elections Division for the Lauderdale County Board of Supervisors, as a grant administrator, and for the City of Meridian as a community development specialist. She is active in civil and social organizations in Meridian and Jackson. She served and is currently serving in the following capacities: past president of the Meridian Community College Alumni Board of Directors, a member of Lauderdale County 2000 Leadership Program, a member of the Meridian Alumni Chapter of Delta Sigma Theta Sorority, which she was chosen as Woman of the Year by the sorority in 1991. She is currently a member of the Jackson Alumni Chapter of Delta Sigma Theta. She serves as a member of the Susan Coleman Breast Cancer Board of Directors and Central Mississippi Chapter of 100 Black Women, of which she served as co-chair of the mentoring program at French Elementary School. She's a member of New Hope Baptist Church, and she serves on the church's administrative staff, chair of Civic, Social, and Political Concern Committee, and she and her husband work with the marital counseling sessions. She enjoys reading, exercising, and serving as a mentor for high schools and college students. She has a son, Joshua, and a daughter, Jabria Clayton, who is also an attorney. Without further ado, I introduce you to my friend, Judge Attorney Bridget Clayton. Thank you, Bridget. We are glad you are here.
Thank you. It's a pleasure and an honor to be here. I do have a 2-year-old grandson who supersedes everyone else. It's a pleasure to be here today.
Yes.
As well as a son-in-law.
Okay. Awesome. Thank you for sharing that information. We do know how those grandchildren are just the apple of the eye, from what I hear.
That's right.
Well, the topic that we will be sharing today, will you just highlight those topics that you will be covering today?
Okay. I will be covering 3 basic, what we call estate planning documents that are very essential at any time, particularly now. And those are, the 3 documents are durable power of attorney, an advanced healthcare directive, and of course, the last will and testament.
Good. And I am so glad you're sharing this information because it's just necessary and important that people recognize that these instruments are vital as it pertains to death. People don't want to talk about death, but this information will be a wealth of information so that people will know the importance of these documents. We'll start with the durable power of attorney. First of all, just share with our audience, what's the purpose of a power of attorney?
Okay, Monique, the durable power of attorney is a document which is all encompassing of putting down in writing what you desire the person, you being the principal, then you would appoint an agent to take on the responsibility of handling your affairs. Mississippi Code 87-3101, commencing at that section in the Mississippi Code, tells us exactly what that document is to do. It itemizes responsibilities. The document can be all-inclusive or it can be limited, but usually with a durable power of attorney, it gives that person that you appoint the ability to act in your stead when for some reason you become unable and capable of handling your own affairs. You don't have to be someone of, sustaining age or an elder or senior. You have to be at least 18 years of age in the state of Mississippi to execute the document. And you would have to have your full faculties. And what I mean by that in lay terms is you have to have a full understanding of the document that you're signing, and as far as a durable power of attorney. And you have to also understand to whom you're granting that responsibility to. So the problem that a lot of people run into is they try to go and do all of these documents when it's a little too late. Of course, if you deceased, you can't do the last will and testament. What we run into in estate planning is when someone needs to do a durable power of attorney, or if they want to do an advanced healthcare directive, they've gotten into a state where that person can't grant that. They don't have the mental capacity to grant that responsibility or to appoint an agent to carry out these responsibilities. Under the durable power of attorney, we'll start with it. You can have a situation to whereas you might have had surgery, you become immobile, you cannot get around and undertake the necessary business affairs or transactions that you would have done had you had your full physical abilities. You need to have done it if you have mental issues. That document would have to have been executed and the responsibility granted to your agent prior to that time. We have to take on responsibility of not becoming a medical person to diagnose. Our background is to do the legal professional aspect of it, but we have to make sure that we're not granting a doable power of attorney for the principal. What I mean by that is we have to make sure the principal is of sound mind when they come in and speak with us, and they understand what they're doing and what they're transacting and the responsibility that they're giving to someone else. So, like I said, we run into so many situations where a sibling or a mother or parent or someone will come in and say, well, I need to get dual power of attorney. And then we get to talking and discussing. The person is in a nursing home. And at that point, it's too late to have that person to grant the responsibility to an agent. So it's very important that as we age, particularly before we start having these, our mental states kind of becoming defective or what have you, or before we get a diagnosis, to have that in place if you wanted to grant someone that responsibility to carry out your affairs.
And I've actually prepared a durable power of attorney for individuals that are in nursing homes, but that's because they have their mental capacity. Right. They may be in a nursing home for other reasons. However, if they have Alzheimer's or dementia, they will not be able to carry out, as you said. And most of the time, I have individuals come up in age to do a durable power of attorney. But I also had a young lady to come and have a durable power of attorney because she was not mobile. She actually had a knee replacement. And she was not able to get out and go to the bank. And so her question was, is this something that we can withdraw after I have had an agent assigned to take care of my affairs? Can I go and remove them and I go back to taking care of my own affairs?
And actually, Monique, yes, the documents can be adopted and framed according to your specific circumstances. And it can be granted for a period of time or until condition dissipates or what have you. You fulfill the responsibility after a certain incident or what have you. For instance, like the surgery or what have you. The doctor might say, well, you might need to have someone handling your affairs because you cannot drive, you cannot go to the bank, to the groceries, or do whatever. And you designate that person that we call an agent for a specified period of time. But most of the time, the dual power of attorney, people are doing it because they have gotten into, before they get into the state of not being able to grant it because of their mental status. But you can grant it, as you say, grant a limited power of attorney is what we call for a specified period of time for various other reasons. And a lot of times the banks, I think it was effective. Really, it became really a little bit more ineffective in the financial realm after 911. The banks, you had a little bit more cumbersome time of trying to get the banks to recognize durable power of attorneys. And, the state area of law carries more than just these three basic documents. So that's why some people even do trusts. They go and do have their financial affairs in a place where they designate someone payable upon death on their accounts. And we always particularly advise some of our senior status persons to make sure that a responsible person is designated, if not by payable on death, but someone to be able to have access to that they can trust and that is financial worthy, and not someone that creditors will come after their money by having that person on their account. To at least have another person, a responsible child, relative, or someone, friend that you can trust on your bank accounts, savings and checkings and that type of thing. CDs, money markets.
And before we leave the durable power of attorney, I have also had this question: does it require a judge to authorize or sign or provide an order of any sort to have the durable power of attorney?
No, as I stated before, we have what we call a trust, and then these documents do not require court approval. So what you're doing is you're getting yourself into a position where your affairs can be taken care of between you as the principal and the agent that you designate. There's no court approval required. When you get into having to have court approval and petitions having to be filed with Chancery Court in our jurisdiction, then that is what we call a conservatorship, which is another area. And like I said, there's various means of trust. We're just doing the three basic, but It just depends on when you come in and seek legal counsel, and we do a consult and see exactly what is needed. But to answer your question, no, the durable power of attorney or limited power of attorney does not grant the approval of a judge. It's between you and the designated person that you want to carry on the responsibility. And a durable power of attorney, I might say this before we move on, is very comprehensive. That you can imagine the things that you would be able to do to yourself, like your business, your bank transactions, any business dealings with any of the entities that you deal with on a business basis. If you have like real estate or what have you, some people have begun to start investing in real estate sometimes for retirement purposes. And if you designate an agent and something happened to you and they've been granted that durable power of attorney, they would have power to go in and to collect your lease payments, to decide if the property has become to a stance that is need to be put on the market. They can enter into contracts with a realtor and just carry out any duties that you would have done that you designated in there. It can be very comprehensive, and as we say, they can be limited as well.
Yes. And we've talked about individuals who may be ill, but I will share with our listeners that I have a gentleman who was incarcerated, and his family called me and hired me to do a power of attorney. And I went to the facility where he was housed as an inmate and actually did a power of attorney because he had a lot of business going on, and he didn't want to lose his property. He didn't want to lose his vehicles. So he designated a family member to take care of his business affairs while he was incarcerated. That's so right. I just wanted to share how broad this instrument can be. So it may not be that you are ill or have medical problems, but I also know some people are traveling and will be away for a sabbatical, working out of the country, things of that nature, and they decide that they may need a durable power of attorney or a limited power of attorney.
Right. And it can be granted. Your agent can be anyone that you trust who's 18 years old of sound mind. Usually married couples grant it to each other. They're each other's agent, And if you have a responsible child, if you're widowed, then a responsible child or a good friend.
Good. Excellent. Thank you so much for sharing that information. Our next instrument is the Healthcare Directive, which is very, very beneficial. It's so unfortunate when individuals have not obtained this instrument because the family runs into having to make decisions for you that you have not made for yourself. Share with us that instrument.
And that's right. When they can't make the decision themselves because they've gotten into a situation to where they're in the hospital, perhaps, or maybe in a hospice, and being in a state where medical records would reveal that they don't have the mental capacity to make a decision, and a major decision as to a lot of times the medications, that type of thing. And we're in the COVID pandemic season, whereas someone close to you being designated your agent would know all about whether you've been vaccinated, whether you're choosing to vaccinate or what have you. They would know if you've had which vaccination you received, if you've gotten a booster, that type of thing. Now, the healthcare directive, as far as the medical profession is concerned, is very essential because all of us have to do annual physicals or what have you. It's always an important thing for your physician to have your advanced healthcare directive in your medical file. And it needs to have that person designated to carry on in your stead when you're not able to do it mentally. What I tell a lot of people when they come to visit with me for consultation in this regard is you don't want a family member to have to make a decision as to whether to keep you on life-sustaining mechanisms. You want to let them ease them with that comfort that they're taking out the desires that you would have them to do in that regard. That's a very hard decision for family members to make if you have not spoken to them about it, or if it's not in writing, Some people come along, if you have several children, they might debate. Some feel strongly about, it's time. And then other ones say, oh no, let's keep mom or dad on as long as they have some inkling of life in them. So if you've done that,
that's the hardest part that I've observed, when the family members are not on one accord.
Right. That's right. So, a lot of times people are, in comatose, in coma, that type of thing. And the children are there, or some family member trying to make that decision, whereas that could have been alleviated. A lot of emotions could have been spared had you had this document drafted as to what your desires are, as far as your last wishes, when you're here and can't make your decisions medically now. The doable power of attorney is encompassing of, your business affairs, those type of things. But the advanced healthcare directive is specific toward medical care. We have what we call the HIPAA violation, the HIPAA Act. So it's very important that they look and see if you say, well, did she have an advanced healthcare directive? The medical providers will, and it's very a good thing to have that with your in your medical records. And they would be contacting the right person that you designated to make important decisions regarding your health.
And does this instrument require court authorization or court approval?
It does not. It's between you and your agent, who you feel that will make the right decision according to your desired wishes and desires that you've itemized, should I say, in your advanced healthcare directive. Now, that document can be found, the provisions for it, on the Mississippi Code 4141-202, commencing with that section of the Mississippi Code. Is with the dual power of attorney and healthcare directive, we might ask the question on all three of these documents, who needs it? Everyone needs it of adult age, 18 years or older. They need to have those in place. And whatever you want to put in them, they can be as limited as you desire, or they can be as comprehensive as you desire. But the important thing is to have your desires designated to the appropriate responsible persons, so that when the time comes, they're in place.
And, this instrument is encouraged by the medical community. My father was being hospitalized, and that's one of the first questions that they ask. Do you have this healthcare directive? And they encourage you to have this instrument because I'm sure they observe situations where individuals don't have this instrument, and sometimes it's pretty it's very trying for the family as they try and get through the medical condition.
Yes. And, Monique, some of the things that you can cover in your healthcare directive in the state of Mississippi as a standard, through the statutes, there are certain things that are required, but it gives that agent, that person you're granting that responsibility to, in regards to your medical decisions, to make decisions about your medical care, diagnosis, surgical procedures, orthopedic procedures, physical rehabilitation, dental procedures, psychiatric or psychological care and treatment, and whether to be admitted into hospital, nursing home, hospice, those type things. What drugs should be administered to you. They would know what you're allergic to, as far as prescription wise in your medical care. So it's very comprehensive. The most essential thing, as we touched upon, is nominating, the most responsible person. You can say when it can be revoked or not revoked or what have you in it. But you would want them to know, your patient advocate, what your desire is as far as being sustained. That's one of the most essential parts in there. So they don't have to make that decision off of what they be puzzled about. Did they do it too soon as far as your care in your last days when you're very ill?
Yeah, the resuscitation part of it.
Right, that's right.
Yeah. And so most people think that that's the only purpose as to whether you want to be resuscitated or not, or if you want the intravenous food and things of that sort. But as you said, it can be broad or limited There's a lot of flexibility with this instrument. However, it is highly recommended that individuals seek out obtaining the healthcare directive.
That's right. That's right. Because in these times, we've always needed it, but particularly now. And I get calls, in particular with this one, when the person, mama, dad, parent, relative, someone is, in a state to where they can't grant the responsibility to an agent.
Hi, this is, let me
call
you.
So that's why preparation, yes, that's why preparation is really needed expeditiously.
Good. Awesome. Thank you for sharing. Our next one is one that I get a lot of calls about, and the highlight of the evening, our last will and testament. Would you share who needs this instrument and why?
Okay. If you're 18 years or older, sound of mind, you need it, regardless of your assets. I think that's what we tend to have so much information out now about the pandemic and what to believe and not to believe, and, follow Dr. Fossey. But anyway, same as this, a lot of us believe that we do not have to have a last will and testament if we don't have substantial assets or, wealth. And that's not the case. I've had people to come in and want to do the senior status, want to do a last will and testament as to specify, very special things. And some of them is like what they're retired to be, at their funerals or that type of thing. But you don't have to be wealthy, in essence, is my point I'm making, to have your desires or last wishes delineated into an official professional document that's drafted clear and concisely as to what you want your last desires to be in your will, who you want to receive what as far as personal property. Personal property as far as your accounts, your financial assets, your wealth per se, could also be real property. And I have a lot of situations where states are open because there are disputes that have arisen between siblings as to acreage. Sometimes, your relatives, your parents would have ascertained some assets as far as real property, which is acreage, homes, those type of things. And this person wants this lot, or this person wants this parcel. So if you go talk to a professional person, an attorney, to help you decide, if I have 100 acres and 10 children, will each child get 10 acres? You just give some consideration to those type of things. The will can be as short as 1 page. It can be 100 pages, depending on your desires that you're going to put down. And no one has to guess what did they want me to do with this or who gets what. It cuts down on debates, after the person is no longer to say how they want to disperse their really personal property. The requirements for that last will and testament will be found in Mississippi Code sections 91.5.1. And it's pretty clear, for what the requirements are. As I stated, you need to be 18 years old of sound mind. Make sure you're designating responsible persons to serve as your administrator or administratrix, so that if your will is probated, then that person will more likely be the person appointed by the court to carry out your last desires of your estate.
And you also have to have witnesses, am I correct?
Yes. Okay. The other requirements are you have to have at least 2 witnesses. And it had been debated for a long time, but Mississippi Supreme Court came down with case law that says that you have to have the 2 witnesses in order to validate. It's always good as attorneys to put an affidavit of describing witnesses, so that if the will is debated, you would have those witnesses, if they're around, one or both of them, to attest to that was that individual's last will and testament. And what I said about the Supreme Court is, with the 2 witnesses are required, but that the 2 witnesses do not have to be present at the same time. You can have one sign one day or whatever. But what is important is that you tell them specifically, this is my last will and testament. when they're executing. They know what they are signing. They have to attest to that you were of a sound mind and understood the bounty or of your assets and what, why you were doing it. And you announced that it was your will, but you have to exhibit to them that you were competent enough to know what you were doing and to understand what your assets are and what you were doing and how you were delineating your property, real and personal, in your will. The witnesses do not, this is another point, they do not have to read your will from top to bottom to know if you're leaving your daughter the $1 million and your son the $500,000. They don't have to know the specificities of each granted request or device. They just need to know that you were competent and rendered to them to the best of their ability, that you knew what you were doing and that you were there and you signed it before notary. It has to be notarized.
Right. And so what an individual wants to change what's in their will, because once you do the will and 5 years later, you may not have the same relationship with that family member that you gave that $500,000 to. What happens under those circumstances?
You can, we call it a codicil. You need to revoke that previous will. And that should be specified. When you go talk to a professional person, an attorney, about, I want to do want you to help me draft my last will and testament. I have one, but I want to revise it, or I want to revoke the previous one. So that should be specified. And each time that you revise it, it should be noted that you have revised it. The dates on them perhaps will say that, but it should be mentioned somewhere that this is a revised or a new will, some sort of term saying that you're revising that document, so that when you pass, you might have designated someone else as an administrator or administratrix, but the dates on them, and you might need to get new witnesses, but it needs to be some type of way that those documents aren't aligned, well, they can't be in controversy. And that witness will be able to say, well, no, we did our signing and witnessing of the will in 2010. And then she had one done in 2025. But the 2010 will should say that all codicils and previous wills or what have you have been revoked. And this is my will. And that's where the witnesses come in. And they are very essential if the will is ever probated. Now, some people think if I do a will, then I end up in court. I got attorney fees or whatever to do the probating process. But that's not always the case. And if your attorney is professional enough and you give them concrete and concise and real specific information, it just depends on the parties, how they're going to conduct themselves after you have the party here. But most of the times you might not have to probate the will. But you are setting yourself up, if you do a will and it's contested, you have to be probated and go through court approval to have all the transactions completed in your estate. And that's why some persons choose to do a trust versus an estate. And we're not going into detail with that because we'll run out of time. But when you do the trust, you're evading probating or going to the court and having things contested or that type of thing. So you just place your assets into the trust. And the trust does not pass through in a state. They're separate and apart, and you won't have to worry about having court litigation.
I was about to ask that question. I'm so glad you went right into that question. That was my next question. The next question, I've had individuals ask, okay, I did my will, I'm still here. Where am I supposed to keep my will? Am I supposed to call and tell the executrix or executor that I've done this will? I really don't want to let them know yet, So what do I do in this circumstance?
Well, I always recommend, the purpose of doing them and having persons appointed to serve as administrator or administratrix is to let them know that you've done it. Of course, with the Advanced Healthcare Directive, I have them assign an acceptance that they wanted to carry on that responsibility. And in the place, speaking of the last will and testament, I would not advise someone to not let their administrator or administrators know they've been appointed. They would need to know that they're going to be responsible for carrying out this person's last wishes. Therefore, when I do that last will and testament, I consult in a way that I recommend that they have all of these essential documents in a special place. And what I mean by that, some people have safe deposit boxes. Some of them have fireproof estate boxes in their home, someplace like that where they're safe and secure, the original documents. And I also request them to let that person that's being appointed, the administrative or the administrators, let them know where the original document is. I even go a little further, Monique. I ask them to provide a copy to the persons who are appointed, the administrator or administrators and the alternates that they've appointed. Let them have a copy. I mean, it could be two people, just have copies so that they will know what is in there, what their responsibilities would be upon the demise of the person that's designated them. And I also ask them, of course, I like to keep a copy. I don't like to keep the original. A lot of lawyers in the day, they would keep the originals, and then the family would call back and say, you did my mom or my dad's will. Where's the original? No, we have long moved away from that, but we give them the responsibility of keeping their original document in a safe and secure place and notifying those persons who've been designated where that original is. And also they would have a copy, a duplicate copy of that original, the persons that have been appointed. So you have your bases covered if something were to happen. You're not running, scurrying around trying to find out what do we need to do, where, who is carrying a policy of, life insurance, that type of thing. You put all those things in there. Where does she have her, who does she conduct her financial business with? Which bank? You can go to the bank, what have you, to see what can we do about that. Because we're already more likely, as we've been advised, to have our names on it. Most of the time, the persons that you want to appoint as an administrator or administrative already have authority to handle transactions with your financial institutions and with your insurance company, with your mortgage company, if you still have a mortgage, those type of things.
Well, the most common question that I get concerning wills is, can I leave someone out of the will, such as a daughter or a spouse?
Always. But when you do those things, if you still married or what have you, kind of might lead you into a will contest or what have you, but it's your will. You can do whatever you choose to do, grant and bequest, devise, however you want to do. It is your document. You just have to have the sound mind, 18 years old, to do it. Your two witnesses. And have it notarized, of course.
Yeah, and then a lot of people tend to stay away from wills because they have a fear that if they prepare a will, they may pass away. And I'm like, well, still, you're going to need a will. Nobody can decide when that's going to happen.
That's right. So we're going to do two things. We're going to die. We're going to pay taxes, right?
Yes, definitely. However, with having the will, what I've found is people feel secure as they move forward in their life. They talk with confidence and knowing that their business is in order. Right. That's the general way the old people used to say, get your business in order.
Right.
And I see that as having your will.
Right. And the other two documents, having someone responsible as an agent under your durable power of attorney, having someone responsible for your medical needs under your advanced health care directive, so that you can be at peace.
Right. And so I think it's important, now that you mentioned all three instruments, you may need that safe deposit box to make sure all of those things are in one central location, because the last will or family that I represented as it pertains to a will, they knew their father had a will, but they didn't know where it was. Exactly. So I had to file a document with the court to get permission to go into the safe deposit box. And luckily it was at one of his banks with the safe deposit box, but he had several banks. So they were busy searching for the will. So I really agree with you when you say, go ahead and tell your family member, this is where it is.
Exactly. That's right.
So that covers those three instruments. One other instrument that we probably could share with our public that fits is the conservatorship. I know I think 2019, Mississippi revamped their conservatorship laws. Right. And it, for a number of reasons as it pertains to guardianship and conservatorship. And now they can do safekeeping and safe observation, because prior to the new law, there was no monitoring, no check and balances, or very minimal accounting as it pertains to conservatorship. So could you share with the audience what a conservatorship entails?
Yes, and you're correct. The Mississippi statutes were revised, whereas previously we had what we would call a conservatorship, and we delineated that for the senior status, persons that were, senior, older adults. And we had a guardianship, which was basically for minors, persons under the age of 21, state of Mississippi, but really 18, unless they were emancipated and declared an adult. But now what we have is a statute now which combines, in essence, is the effect of it. To make a long story short, the current conservatorship and guardianships are one, in that we have what we call their conservators designated by court over the person, and their guardian over their estate. We have real specific requirements as to what they have to report on that person, where that was not required. An accounting perhaps would have been required. But now you have specific reports that the court requests that you prepare if you're going to be appointed as the conservator of an individual. So you would have a dual role where, we used to have it separate, where you would just maybe get appointed to be the conservator of someone's estate where you handled their business affairs for them, but you were not necessarily responsible for their care as far as being a guardian and handling their nutrition and their the medical care, that type of thing. So now all of that is required that you do this reporting once you get appointed as a conservator. So it's a little bit more comprehensive and entails a lot more responsibility than it did. You can't bifurcate responsibilities of saying, I just want to do, one or the other. You have to make sure that you're willing to do that comprehensive care of the person, because reporting is required now. More visited than it had been.
In the time frame of 90 days, you can expect that you've got to present to the court to give them an update on the use of the assets and property that you may be managing. The other thing about the conservatorship, as we talked about the power of attorney, I've explained to clients, they come in saying, I would like a power of attorney, which is what you mentioned earlier. But if the person is incapacitated, I tell them that the only instrument that would probably be beneficial or necessary would be a conservatorship, which requires a court authorization or order.
Right. You have to commence that with filing a petition to get that person appointed as the agent, per se, or the conservator of the individual, for whatever reason. Yeah.
Right. And that's also revocable, a conservatorship, because sometimes you have people that aren't doing a good job. I think the most popular one is Britney Spears right now, know?
Right.
She was under a conservatorship with her father, and I think one other designated person, and I think recently they were removed.
Yes, her dad was. He had been her conservator for years. You're exactly right. The situation with that is you can't, now it was in the previous statute as well as now, it's still there. The mandate that if you're trying to become conservator with someone who doesn't have the mental capacity, that statute requires you to have 2 certificates of physicians. Those certificates from the physicians, the statute requires 2 to be on file or to be attached as exhibits to your petitions, saying why this person, you are needing to be appointed as a conservator of that person. Those medical certificates state specifically, and then they have them specific with specificity according to the statute what has to be in them regarding the person's medical condition. So those are required for a conservator. But, and as you mentioned too, if someone petitions and says, well, you appointed Mary Jane as a conservator, but she's not living up to her responsibilities that's required of her under the statute that's required, the responsibilities that are delineated for that person to undertake as conservator. Someone can petition the court, and it's up to the court discretion to decide. And that's why they started requiring, as by statute is revised, and you spoke, to have reportings that are required with the court as to what your plan of care is for this person.
Right. And I also think that an oath is necessary.
Right.
Where the person that's stepping in to serve, they go before the court promising that they're going to do a good job and they're not just in it to maybe reap benefits, that they're going to look out for the best interests of the ward.
That's right. They're also required to file what we call a notice to creditors and an affidavit, because creditors have to know if that person is receiving any type of benefits, Social Security, retirement plans, that where they might have worked for a public or a private institution, receiving pensions or whatever. They have to work with those entities. So you have to give them notice, letting them know that you're petitioning the court to assume the responsibility if appointed as a conservator for that particular individual.
Well, your knowledge has been incredible this evening. What I'd like to do is get a little personal. Will you share with our audience why you pursued the legal profession?
I always have the strong desire to, number one, be a leader. And, being an attorney requires you to be a leader. If you can't have what they say, you got to have a little soft personality if you're going to be in the legal profession. And I've always been a strong type personality. I desire to lead. And above all, I desire to help. You get much more reward from at the end of the day when you've helped someone. I always try to align myself with Mississippi Volunteer Lawyers Project. I helped as a volunteer lawyer through Katrina, and I've taken on. I choose my home county, Lauderdale County, to do some pro safe with Mississippi Volunteer Lawyers, just to do some work for persons who cannot afford, our legal fees or what have you. So I desire to help. I desire to lead. I'm a community servant person. I love mentoring. As you might notice in my curriculum vitae, that I do like to mentor persons from high school to the undergraduate that have a desire to become actively involved, whether it be an attorney or whatever, in some aspect of law enforcement, of becoming an attorney, just to mentor them along. I have had several students over the years to just follow me. When I was on the bench, they would come to municipal court. They come to my office and, let them see what I actually do every day. Because, it's just different, from being in law school, the actual practice of having that realization in the field for what the profession entails. But I have thoroughly enjoyed it. I think it was about 8th grade. I decided I wanted to be an attorney. So, yeah. And I know most of your guests have mentioned Constance Slaughter Harvey. She's our soror, and she's a tremendous mentor. She has been that for me over the years. I worked under the auspices of Connie when I worked with the Secretary of State's office, and was, coming right out of law school, and then just have walked in her shadows ever since, because she is the epitome of a true servant. Servant leader is what we want to be.
Yes, she is.
That's what I want to emulate, and my legacy to be. As you know, my daughter and my son-in-law are attorneys. So we're proud of that, and just like to lead and to serve at the same time.
Well, we appreciate all that you do, serving the community and making a difference with your mentoring and just with practicing law and all of the work that you do throughout Mississippi. I wanted to just commend you on all that you do. And thank you so much for coming and sharing this wealth of information to our audience. Would you please provide your contact information just in case we've got some viewers who need more information or details on a legal matter?
Yes. My telephone number, of course, is 601-961-9494. And I have post office box 13953, and that's Jackson, Mississippi 39236. And I am listed, various ways, so you can find me. And my email address is attybmc@bellsouth.net.
That's awesome. That's awesome. We at Women for Progress thank you, and we just want to thank all of our women attorneys. It's so important that we step in and provide information to our community as it pertains to legal matters, because they matter. And this podcast has just been helpful as we move forward with various issues. Before we conclude, I just want to let our viewers know I am Monique Montgomery, and I've served as the host of Legally Speaking. And I ask that you please provide questions and legal issues that you may have or would like for us to highlight throughout the weeks. Next week, we will have attorney Greta Mack Harris, and she is a candidate for county court judge. So if everyone would join us, currently she serves as an assistant district attorney for Hinds County. And so we look forward to having our viewers with us next week. Once again, Bridget, thank you. And I just want to thank Women for Progress and our president as we move forward, helping women with legal matters. Thank you for joining Legal
Recording
Speaking,
stopped.
and Godspeed to all of you. Good night.